Thank you, everyone, for coming. Happy Constitution Day. So on this day in 1787, the U.S. Constitutional Convention signed our Constitution, and that's what we're commemorating today. Welcome to this Constitution Day event sponsored by the American Constitution Society and Harvard University as a whole. My name is Sophie Kim, and I am the president of the American Constitution Society. For those unfamiliar with us, the American Constitution Society promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. We believe the law should be used as a force to improve the lives of all people. And we're very happy to have with us today Professor Michael Klarman, who is the faculty sponsor of ACS. He'll be talking about the founding and why the U.S. Constitution should not be given undue reverence. To give you a bit of background about Professor Klarman, he received his bachelor's and master's in political theory from the University of Pennsylvania. I know we have some UPenn alums here, proud UPenn alums. His JD from Stanford Law School, and his DPhil in legal history from Oxford, where he was a Marshall Scholar. After law school, Professor Klarman clerked for the Honorable Ruth Bader Ginsburg on the U.S. Court of Appeals for the D.C. Circuit. Professor Klarman has won numerous awards for his teaching, and anecdotally, I've heard from numerous friends that he is the best teacher that they've ever had, not just in law school, but ever. So make sure to take his course once you become an upperclassman if you're a 1L, or if you're an undergrad, maybe, if you can. I don't know if there are opportunities to take your course. But, and he's received many awards for his scholarship, primarily in the areas of constitutional law and constitutional history. In 2009, he was inducted into the American Academy of Arts and Sciences. Professor Klarman's first book, From Jim Crow to Civil Rights, the Supreme Court and the Struggle for Racial Equality, received the 2005 Bancroft Prize in History. He published in 2007 two books on racial equality, Brown versus Board of Education and the Civil Rights Movement, and Unfinished Business, Racial Equality in American History. Most recently, in 2012, he published From the Closet to the Altar, Courts, Backlash, and the Struggle for Same-Sex Marriage. And he is currently working on a revisionist history of the founding. Please join me in welcoming Professor Klarman.
Thanks, Sophie. So you fell for the classic bait and switch. There is no pizza coming. Thanks very much for coming. Thank you to ACS for inviting me to do this talk. We're gathered here today for three reasons. First of all, it's Constitution Day. Today, September 17, 226 years ago, the 39 framers who were still present in Philadelphia signed the Constitution. So that's reason number one. Second, my youngest daughter turns 13 today. Her birthday is Constitution Day, which is maybe perhaps fitting. She was adopted from Azerbaijan, so she became an American citizen, and now she's turning 13. And then finally, the Boston Red Sox, if you haven't noticed, are 9 games in front, playing in the toughest division in the American League. So I appreciate your joining me to commemorate all three of these events. The theme, especially those of you who are Yankee fans, who I feel somewhat sorry for these days. The theme of the talk, of course, is that we ought not to blindly revere the framers, but I have no problem with blind reverence for the Red Sox, so I'm not debunking all myths, only myths about the founding of the Constitution. I'm working on a book about the founding, as Sophie mentioned. It's a book for Oxford University Press, a series that they do on inalienable rights. The tentative title is Reconsidering the Founding, but that's a pretty crappy title, so if people want to suggest something better, I'd be happy to hear any and all suggestions. We obviously do have a tendency to venerate the Constitution and revere the founders, almost indeed to deify them. I don't think that's a particularly healthy tendency, and I want today to puncture that myth and perhaps a couple of other myths as well. So there are actually 5 discrete topics I'm going to talk about today. First is a point about the contingency of the Constitution. Things certainly did not have to work out the way they did, and it's a pretty interesting question. If they hadn't worked out the way they did, what changes that might have entailed for the country. Second is a point about interest group conflict. The Constitution is not the product of a bunch of disinterested wise men, and it's worth emphasizing at this point what is obvious. They were all men, they were all white, and they were all property holders, and that right there ought to give us pause before revering them. But leaving that aside, the Constitution was not a function of disinterested wise persons simply sitting back and reflecting on good schemes of governance. It was about political and economic conflict. People disagreed about fundamental questions of fiscal and monetary policy, which were much more important to the Constitution than I think you're probably taught in high school civics classes. They disagreed about how much democratic influence was a good thing in government, and they disagreed fundamentally about what sort of nation they wanted ours to become. There were clear winners and clear losers as a result of the struggle over the Constitution. Third, I want to make a point about democratic legitimacy. Both the procedures that were used to enact the United States Constitution and many of the substantive provisions in it were departures from practices that had developed in the states in the 1770s and 1780s that were in fact much more democratic. And I think we ought to be at least a little bit troubled by that. The Constitution was actually a retrogression in terms of democracy from what preceded it. And then finally, I want to make 2 points towards the end, which are less about the Constitution and how it came about, and more about how the Constitution has evolved over time. Evolutions that may call into question precisely how important the Constitution is to the way that we govern ourselves. So point number 4, to a very substantial degree, the Constitution has become irrelevant to our current political arrangements. I don't say it's become entirely irrelevant, but to a more considerable degree than you would intuit. And then fifth and finally, the rights protections that we enjoy today, and I don't for a second intend to minimize the importance of them, but those rights protections we enjoy are much more a function of political and social mores, which have evolved dramatically over time, than they are to courts enforcing the Constitution as written 226 years ago. Okay, so those are the 5 points, starting first with the point about contingency. Because the Constitution is so fundamental to the way in which we conceive of ourselves as a people, it's hard for us to wrap our minds around how much of the process that produced it was contingent, by which I mean simply almost an accident. Things didn't have to work out the way they did. For starters, the Philadelphia Convention almost did not take place. As some of you may know, it resulted from near desperation after a convention that had been called several months earlier in September 1786 to meet in Annapolis and to discuss commercial problems that the states were suffering under. After that Annapolis Convention was stillborn, Madison and Hamilton took a shot and decided to issue a call for a larger convention with a broader agenda to meet in Philadelphia the following May of 1787. Had it not been for concerns that were caused by Shays' Rebellion, again, some of you might be familiar, but probably most of you are not. Shays' Rebellion was an effort by a couple of thousand farmers, mostly in central and western Massachusetts, to shut down the courts rather than have their farms foreclosed upon, and it was suppressed by an army that was put together by eastern Massachusetts, mostly Boston creditors. Had it not been for Shays' Rebellion, it's not clear that enough states would have sent delegates to the Philadelphia Convention for it to be successful, and it's likely that George Washington would not have attended, and his presence was probably pretty significant for conferring legitimacy on the convention. The Philadelphia Convention, having successfully met, came very close to failing, mostly as a result of intractable disputes between small states and large states, fundamentally over the question of how to apportion representation in the national government. Even after the convention managed to successfully recommend a constitution in September 1787, there was nothing like a guarantee that it would be successfully ratified by the requisite 9 states. A couple of states, Rhode Island and North Carolina, initially rejected the Constitution before later falling into line. And probably more importantly, several large states, specifically New York, Massachusetts, and Virginia, were so closely divided over ratification that nobody could predict with any confidence what was going to happen. And in the end, those states did ratify, but by very, very narrow margins. Even with the Constitution ratified and put into effect, there would not have been a Bill of Rights, which we tend to think of today as a fundamental charter of our liberties, had it not been for James Madison, who did heroic service in the cause of a Bill of Rights, mostly fulfilling a promise he had made to his constituents in return for them electing him to represent Virginia in the first Congress. So things did not have to turn out the way that they did. And as I said, it's a very interesting question how differently the country might have turned out without a constitution. There was at least serious discussion in 1786-87 of the Union breaking apart into 2 or 3 separate regional confederacies. Second point. It's wrong to think of the founding, as some constitutional theorists have done, as simply a bunch of wise statesmen setting aside their interests and dispassionately considering the question of the greater good of the American community. The contest over ratification featured a veritable smorgasbord of interest group conflict. One of the most important and basic conflicts that underlay the Constitution were the provisions in Article 1, Section 10, which most people who take a constitutional law course today don't even know what those provisions involve. Those are the ones that bar state governments from emitting paper currency and secure contracts. Specifically, they were thinking about debtor-creditor agreements from retrospective impairment by state legislatures. We tend to think of the Constitution largely as a response to flaws in the Articles of Confederation. For example, the absence of power in Congress to impose mandatory taxes or to regulate commerce, the absence of any strong guarantee of federal supremacy, and the absence of any federal executive or judicial system, which is what characterized the Articles of Confederation. And to be sure, the Constitution was, in part, a response to those obvious flaws in the Articles of Confederation, but at least as importantly, and again, I think I'm probably telling you something that for many of you is new, but I don't think this is actually controversial among historians who've spent much of their lives studying the period. The Constitution was at least as much a response to what was going on in the states in the 1780s, which was deeply troubling to leading statesmen like Madison, Hamilton, and Washington. The country faced a severe economic recession after the end of the Revolutionary War. There was, as there usually is after wartime, less demand in the economy, with the wartime needs of the army evaporating. There had been widespread destruction of property during the Revolutionary War. Literally tens of thousands of Southern slaves had emancipated themselves during the war, leaving Southern plantations and in the process wiping out vast amounts of the wealth of Southern whites. And in addition, importantly, after the war, the British shut off the West Indies trade, which had been a critical component of the American economy. Now the United States was no longer part of the British Empire, so the British weren't going to allow Americans free trade with the West Indies. At the same time that the economy was slumping, states were imposing even heavier taxes to finance the war debt and to pay their requisitions from Congress, which in turn were largely addressed to financing the war debt. Furthermore, the war debt, bonds, paper money issued by states and by Congress, the war debt had become increasingly concentrated in the hands of a smaller number of speculators who had bought government bonds at a fraction of par value and stood to make a killing if they were now paid off at face value. And these creditors, these holders of government bonds, not surprisingly, were demanding higher taxes and rigorous collection so that they would be paid. Finally, those taxes being imposed by the states and the requisitions imposed by Congress often had to be paid in gold and silver, and there was very little of that in circulation, much of it having departed the country, fleeing to Europe to finance what was a perpetual trade deficit. So the bottom line is that thousands, indeed tens of thousands of farmers were unable to pay their taxes or repay their creditors, and many of them were seeing their farms foreclosed upon. In many states, demands for debtor relief then led legislatures. The United States had the broadest suffrage in the world, so that many of these debtor farmers had the requisite property to enable them to vote. Demands for debtor relief legislation led state legislatures to capitulate and pass debtor relief laws, pass paper money emissions, and sometimes pass laws making it easier to pay off your debts. People like Madison and Hamilton regarded those laws as an interference with the natural rights of property. They saw them as essentially nothing other than theft from creditors to debtors. They also feared that those measures would make it impossible for government again to borrow money. Who's going to lend money if the government's playing around with the rules of repaying on contracts? They thought it would make it impossible to borrow from domestic and foreign creditors, and they blamed those measures on an excess of democracy in the state governments. Legislatures that were too responsive to the demands of their constituents because of annual elections, which was by far the dominant mode of elections in state constitutions, direct elections by the people, reduced property qualifications to vote, and small legislative districts where there was a very tight connection between constituents and their representatives. Those who were seeking relief, by way of contrast, tended to see these measures as a sensible relaxation of fiscal and monetary policy at a time of severe economic contraction. The measures they believed were necessary in order to avoid foreclosures on farmers who had been overburdened by taxation, and as an effort to keep speculators from making a killing on government bonds that they had bought up at as little as 5 or 10% of face value. The relief seekers actually criticized legislatures for not being democratic enough in responding to their needs and demands. In a state like Massachusetts, which did not provide relief and actually was jacking up the severity of taxation in 1786, debtor farmers joined a rebellion led by Daniel Shays, who was a Revolutionary War officer. Even scarier to many conservatives than Shays' rebellion was the fact that those who were seeking debt relief in Massachusetts won the 1787 state elections and got some of the relief they were seeking from the state legislature, the new legislature that was adopted in the spring of 1787. Shays' rebellion is a famous episode in American history, but there were actually scores of other instances, especially in the back country, the area along the western periphery of the United States, with courts being closed in some parts of a majority of states in the middle 1780s. People who felt that affairs in the states were starting to get out of hand thought that a stronger national government might be able to solve some of these problems, not only by barring debtor relief and paper money emissions, but also, for example, by empowering the national government to suppress insurrections, including not only slave insurrections, but also any future insurrections by debtor farmers. Longer terms in office, larger constituencies, indirect elections, those would all make the national government, according to the designs of the framers, less responsive to the demands of relief seekers than state governments had been in the 1780s. The Constitution gave creditors much of what they wanted, and as a result, they overwhelmingly supported the Constitution. But there were many other interest groups that largely supported the Constitution as well. Merchants, shippers, and manufacturers overwhelmingly favored the Constitution, in large part because it gave Congress the authority to regulate interstate commerce, which would enable the national government to retaliate against British trade restrictions and also to impose protective tariff barriers, which would enable American manufacturing to get a start, being protected from British and European competition. Small states like Delaware and Georgia quickly and decisively ratified the Constitution, largely because they had secured such a good deal in the United States Senate, which of course is equally apportioned, with tiny Delaware getting the same representation as giant Virginia. Also, those small states could not plausibly go it alone, as a large state like Virginia perhaps could. States such as New Jersey and Connecticut strongly endorsed the Constitution, partly because it would liberate them from paying the hated import duties that had been imposed in the 1780s by New York, which had a better natural port than those states, and therefore raised much of its state revenue by taxing imports that came through New York Harbor but were ultimately destined for consumption in surrounding states. Finally, the better sort of people, the well-educated, well-born quasi-aristocracy, generally supported the Constitution, at least in part because through large constituencies, indirect elections, and long terms in office, they were calculating that their chances of being elected to national office would be enhanced. Opposition to the Constitution was also, not surprisingly, largely driven by considerations of interest. For example, Westerners in states like North Carolina and Virginia generally opposed the Constitution. By Westerners there, I mean the people who'd already crossed the Appalachian Mountains and had settled in what would soon become the states of Kentucky and Tennessee. They largely opposed the Constitution, mostly out of fear that Congress would use its treaty power to bargain away their claims of access to navigation on the Mississippi River in negotiations with Spain, but also because they figured if Easterners are supporting the Constitution, that's probably good enough reason for us to oppose it. Westerners were tired of Easterners who lorded it over them in malapportioned legislatures, who made fun of their unpolished manners and their inferior educations, and tended to allocate tax burdens in ways that were disadvantageous to those who had migrated westwards. Other opposition to the Constitution was also primarily motivated by considerations of interest. Debtor farmers, like those who had recently revolted in central and western Massachusetts, they tended to oppose the Constitution because Article 1, Section 10 suppressed paper money laws and debtor relief laws. Many New Yorkers opposed the Constitution because it would end their state's ability to extract tax revenue through neighboring states via the import duties. Many Southerners opposed the Constitution. There was larger opposition to the Constitution in the South because they feared that Congress would use the commerce power in ways that would benefit Northern shippers to Southerners' disadvantage, because they feared that the North would dominate the equally apportioned Senate. Most people thought of there being 8 northern states and 5 southern states at the time of the founding. And finally, some of them feared that slavery was insufficiently protected from federal interference. So I don't mean to say that the entire fight over the Constitution was simply about interest group conflict. There were certainly differences over ideas as well, but interest group conflict was preponderant, and the image that many of us have absorbed of a bunch of very wise and virtuous people sitting around reflecting on abstract political theory is, I think, absurdly distortive of what was actually going on in the country in 1787, 1788. Okay, moving on to my third point. There are some troubling democratic deficits, both in the substance of the Constitution and in the procedures by which it was enacted. Those, I think, ought to give us pause today if we're inclined toward blind veneration of the document. Many of the substantive provisions in the Constitution, as I've already suggested, contravene the more democratic provisions that had been adopted by states when they wrote constitutions, which most of them did between 1776 and 1780. State constitutions of the 1770s tended to use direct elections, meaning the people vote directly for office holders. They had annual terms in office everywhere for legislatures, in most places for governors. They had tiny legislative districts, and they often had mandatory rotation in office to prevent an entrenchment of government officials. Evaluated against that baseline, the Constitution is an extraordinary departure from direct accountable government. Indirect elections of senators and presidents, enormous constituencies. The first congressional representatives represented 10, 20, 30 times the number of people that state legislators represented. Vastly longer terms in office, 4 years for the president, 6 years for senators. They'd openly talked at the Philadelphia Convention about even longer terms. Several of them favored life tenure for presidents. Many of them talked about 10 or 15-year terms for senators. And finally, no provision for mandatory rotation in office. So those are the substantive departures from the more democratic baseline in the states. In terms of procedural democratic deficits, even leaving aside the stock objections, which are real objections, that many people were not allowed to participate because they didn't hold enough property, and that no women or non-whites were allowed to participate in voting at the time. But even leaving that aside, the process lacked democratic legitimacy in a number of ways. The Federalists, the people who were responsible for the Constitution and then the ones who supported its ratification, they generally exhibited profound distrust for the people. They blamed the debtor relief laws and the paper money emissions on quote-unquote democratic licentiousness. Behind the closed doors of the Philadelphia Convention, and it was critical that they maintain secrecy because many of the things they said they would not have wanted repeated in front of the people. Behind the closed doors of the Philadelphia Convention, they regularly referred to democracy in the most disparaging of terms. Quote, the worst of all political evils, close quote, according to Elbridge Gerry, a delegate from the state of Massachusetts. For the most part, what the Federalists tried to do after they got the Constitution written was to preempt debate on it and simply get it passed. In state ratifying conventions, they pushed for quick votes. They opposed paragraph by paragraph deliberation on the Constitution, and they tried at least initially to foreclose any amendments being proposed. Outside of conventions, they tried as hard as they could to stifle open and robust debate over the Constitution. They retaliated through economic boycotts against newspapers that dared to publicize opposition literature from the anti-federalists, the people who were arguing against ratification. Some ratifying conventions, most notably in South Carolina, approved the Constitution only because of extreme malapportionment, which benefited supporters of the Constitution by artificially minimizing the influence of the more populous western counties whose population was growing, but the legislature had failed to reapportion, and thus the state ratifying convention had failed to reapportion. So South Carolina ratified, even though almost certainly a majority of citizens in the state opposed the Constitution. For all Federalists, the utmost priority during the ratification struggle was to avoid a second convention, which is what many anti-federalists were proposing as a way of perfecting the document. Federalists worried, I think with good reason, that they could never duplicate the strongly nationalist document that had produced by the Philadelphia Convention. Now that the people had been awakened to what the Federalists were trying to accomplish, and they were alert to the kind of quasi-nationalist coup that the Federalists were trying to pull off, they never could have repeated that at a second convention. So to sum up that third point, the Constitution provides for much less democracy at the federal level than most Americans in the 1780s had experienced, had become accustomed to at the state level. In addition, it was ratified through a process that was stacked against democratic deliberation. It's not obvious why one today should want to pay blind obeisance to such a document. Okay, moving on to, any sign of pizza yet?
There is pizza outside, so we can wait until your talk is over and have people go out before Q&A, or we can have them go out now.
People are hungry, right?
And then have them come back.
I'm happy to take a 5-minute break so people can get some pizza. Okay, so I know a lot of people have 1 o'clock classes. I'm sure we have to end at 1, and I definitely want to leave a little bit of time for questions. So I'm going to skip point 4, which was about the increasing irrelevance of the Constitution. I'm just going to move to the 5th point, and then I'll stop, and I think that'll only take me another 8 or 10 minutes to get through. Okay, so the Constitution's important in terms of protecting individual rights through judicial review. Surely that's something that we ought to justly take pride in, and which make it appropriate to celebrate the Constitution today on my youngest daughter's 13th birthday. It turns out, unfortunately, that the Constitution hasn't been that important in that regard either. I don't want to say the Constitution is completely irrelevant with regard to the protection of individual rights, only mostly so. Courts interpreting the Constitution have failed to protect rights that we value today, at least as much as they have protected them. And when they have succeeded at protecting them, it's mostly because public opinion has evolved in favor of those rights, rather than because courts have heroically defended oppressed minorities against majorities. Those are actually 2 separate points, so I'm going to treat them separately, and then I'll finish up. So a word about each. With regard to courts' failures to stand up for rights, in the famous Dred Scott decision in 1857, the Supreme Court, of course, protected the rights of slaveholders, not the rights of slaves. In Plessy versus Ferguson in 1896, the Supreme Court rejected a constitutional challenge to state-mandated segregation. In Korematsu, the court upheld the Japanese-American internment. In the late 1910s, during the first Red Scare, and then again in the 1950s, during the second Red Scare, the court approved the criminal prosecution and political persecution of political leftists. And before 1970, the court consistently and repeatedly denied that women had any equality rights to be protected under the 14th Amendment. In Bowers versus Hardwick, finally in 1986, the court said in an opinion dripping with homophobia that the Constitution permitted states to criminalize same-sex sex relations between even consenting adults. Now, you might be inclined to respond to this line of criticism along the following lines. Sure, the court hasn't always protected minority rights in the way we would like, but the court has done some great things along the way. The court struck down school segregation in the 1950s. The court protected the rights of unpopular criminal defendants beginning in the 1960s. The court protected the rights of women beginning in the 1970s. Now that leads in turn to my other point, which is with regard to the court's protection of individual rights. Yes, it's true there are some court decisions in American history that are favorable to civil rights and civil liberties, but virtually all of those consist of Supreme Court decisions that reflect evolving social mores. None of these rulings contravene the strong preferences of the American public. Most of them were actually supported by a majority of Americans on the day they were handed down. Most famously, and perhaps most surprisingly to many of you, Brown versus Board of Education was supported by a slender majority from the day it was decided. Brown was a function of dramatic changes that were taking place in the country, largely as a result of World War II. Before Brown, Jackie Robinson had desegregated Major League Baseball, and before Brown, Harry Truman had issued an executive order beginning the desegregation of the American military. Ralph Bunche, a black man, had won a Nobel Peace Prize before Brown. Justice Felix Frankfurter had hired the court's first black law clerk in the years before Brown. President Roosevelt had appointed the first black general in American history during World War II. Even in the South, dramatic changes were already afoot in the decade or so before Brown. Black voter registration was growing by leaps and bounds. African Americans were being hired as police officers for the first time since Reconstruction. Blacks were serving on juries again for the first time since the late 19th century. And even in Deep South cities like Birmingham and Montgomery, Alabama, African Americans were integrating minor league baseball teams. I should point out tangentially that if you wanted to, if you're inclined to, and sometimes I am, you could tell pretty much the entire history of the United States through the lens of baseball. That's the subject for the next book. The justices in Brown understood that they were riding the crest of a wave of racial reform. They were not creating a brand new movement for social reform. Similarly, the court in the 1970s did indeed strike several blows for gender equality. All of those came after, not before, Congress had passed by the requisite 2/3 majority the Equal Rights Amendment. Most of the court's decisions in the 1970s striking a blow for gender equality simply struck down a handful of anachronistic laws in a few outlier states. Prior to 1971, the Supreme Court literally never lifted a finger in the cause of gender equality. Lawrence versus Texas in 2003 did indeed strike down state laws criminalizing same-sex sodomy, overturning the court's earlier decision in Bowers versus Hardwick. But that decision in Lawrence came down after the vast majority of states had already decriminalized same-sex relations, and even those states that still had laws on the books banning the activity essentially never enforced the laws in practice. The court struck down the Defense of Marriage law in 2013 at a time that polls showed roughly 2/3 of Americans thought the law should be repealed. The court's first recognition of the right to privacy under the Constitution came in 1965 in a case from Connecticut, where the state had criminalized the use of contraceptives so broadly that it even applied to married couples using them in the privacy of their own bedroom. At the time of the decision, there were only 2 states in the country, the 2 states with the largest Catholic population, that still refused to recognize such a right. Like much of American constitutional law, that decision, Griswold versus Connecticut, is an instance of the court taking a dominant national norm and imposing it on a handful of resistant outliers. That's what the Warren Court did best, usually under the guise of suppressing Southern outliers, but occasionally, as in Griswold, suppressing Catholic outliers. The court's recognition of a right in 1963 for indigent felony defendants to have state-appointed counsel, Gideon versus Wainwright, came at a time when only a handful of states, almost exclusively in the South, failed to recognize such a right of their own volition. So I don't want to say the court never stands up for unpopular rights and unpopular groups, but it rarely does so, and I think never in the face of overwhelming public opposition. The main reason for that, of course, is that the justices are too much a part of contemporary culture and the current historical moment to even imagine taking positions that are strongly out of line with dominant opinion. The NAACP wouldn't bring a case challenging school segregation before World War II because the lawyers simply assumed that they would lose such a case in the Supreme Court. Not even the American Civil Liberties Union dreamed of challenging restrictive abortion laws in court until the mid-1960s, because before the explosion of second-wave feminism in the late 1960s, the idea of a constitutional right to abortion would have struck almost everyone as inconceivable. Groups like the American Jewish Congress refused even to bring constitutional challenges to state-sponsored school prayer until about 1960, because nobody could imagine the United States Supreme Court would invalidate that practice until after the demise of the nation's unofficial Protestant establishment. Gay marriage cases were almost literally laughed out of court when they were first brought in the 1970s. None of the national gay rights organizations wanted to get behind such litigation until fairly recently, until the last 2 decades, because they understood the basic point that I'm making. Courts are too much a reflection of public opinion to ever get too far out in front of it. So to conclude this last point, we do indeed have many political accomplishments in the nation that we ought justly to take great pride in. The United States has a strong tradition of freedom of speech, free exercise of religion. We have general racial and ethnic tolerance. We have rapidly growing toleration for diversity and sexual orientation. But these accomplishments, I think it's vital to realize, these accomplishments are due more to who we are as a people than they are to the Constitution or courts enforcing that document. The Constitution was written well over 200 years ago by people who had very different concerns and who held very different values. They did not value gender and racial equality the way that we do today. They certainly did not believe, for example, in a right to sexual autonomy. Their notions of free speech were vastly more restricted than our notions today. And despite the First Amendment to the Constitution, for the most part, the framers had no problem with established churches at the state level or with public displays of Protestant Christianity by government officials, displays that most of us today, many of us today, would find deeply exclusionary. And the Supreme Court, for most of its history, upheld racial segregation and race-based disenfranchisement, the subordination of women and gays and lesbians, the criminalization of dissident speech, and a very narrow conception of the separation of church and state and the rights of criminal defendants. In the end, it's important to recognize it's we, the American people, who determine the sort of country that we have. The Constitution and the courts play a relatively marginal, not an irrelevant, but a relatively marginal role in that process. So if I might paraphrase the great jurist with an even better name, the greatest possible name for a judge, the Honorable Learned Hand, no constitution and no court are going to rescue us from white supremacy or from sexism or homophobia or Japanese American internment or FBI profiling of Arabs and Muslims. We have to do those things for ourselves if we're going to do them, and to believe otherwise, I think, is a delusion and possibly quite a dangerous one. So we have a little bit of time for questions, or if anyone wants to join me in a round of applause for the Red Sox, who are the best team in baseball. But I'm eager to hear your thoughts, so hold the applause, and we can take a couple questions, and then we'll let people go. I know people have classes at 1. So any thoughts? Yes, sir.
I had a question about Shays' rebellion.
Yeah.
Most people would say that that concern was covered by Article 4, Section 4 of the U.S. Constitution. And that contains 3 pieces which are rather interesting. One is a guarantee of a republic. The second is the response of the federal government to a foreign invasion. And then the concern of Shays' rebellion was if you get a request from a state to deal with a rebellion, the government should be able to help out. I'm interested in the very first part of that, the guarantee of a republic in a federal document, because we have a state constitution which is routinely ignored, and it has 30 elements of its Declaration of Rights. Article 7 is fascinating. It says, the purpose of government shall be for the common good and not for the profit of any man, family, or class of men. If you enforce that, you'd put the state legislature out of business. So what I'm wondering is, could you go into federal court and request that the federal government take action against the Commonwealth of Massachusetts for not providing us with that element of a republic?
So a couple things in response to that. I think the framers mostly meant by a guarantee of a republican form of government that states ought not to be granting titles of nobility any more than the national government. But short of that, short of titles of nobility, they clearly believed there was a vast spectrum that could be encompassed within the idea of a republican government. So in a sense, they're all Republicans. None of them believed in instituting a monarchy. On the other hand, they believed that you could have senators serving 6 years, 9 years, 15 years. Alexander Hamilton made a famous speech at the convention on June 18th proposing life-tenured senators, life-tenured president, because he thought only life tenure could sufficiently guarantee that you would have the ability to ignore popular demands for things like debt relief and paper money emissions. So Republican government, yes, but the minimum, all that really meant was we're not conferring titles of nobility, we're not appointing a king. thing, but we can have indirect elections, large constituencies, long terms in office, no mandatory rotation, and that all qualifies in their mind as Republican. Now, on the second point about judicial enforcement, you can go into federal court and ask for anything you want, but that's going to be a losing cause of action. The Supreme Court said in the 19th century, in a famous case from Rhode Island in the 1840s, when one government was being forcibly challenged. The state of Rhode Island had literally not rewritten its constitution since before the founding, and it still had significant property restrictions, and the legislature was refusing to capitulate to popular demand to expand the suffrage, so people took it into their own hands. If the government won't respond, you have a popular rebellion, and then both the rebels, this was known as Dorr's Rebellion in 1842, the rebels and the government both claimed to be legitimate, and somebody brought a lawsuit, a trespass case, where somebody had broken into someone else's house and claimed, well, I had the authority to do it because I'm part of the government, and then the response was, well, you're not really the government. And the Supreme Court said that's a political question. We allow that to be adjudicated by the political branches of the national government. Congress and the president decide whether a state has a Republican form of government. Then this was a big issue during Reconstruction, when Congress forcibly reconstructed the southern state governments, forced them to write new constitutions, forced them to enfranchise former slaves against their will. And then the question was, where does Congress get the authority to do that? And the main ground was Congress was creating Republican governments because states, by disfranchising African Americans, who in several states were a majority of the population, radical Republicans said that's not a Republican form of government, and Congress was counting on the courts not being willing to adjudicate that because the Supreme Court had said 20 years earlier that we don't adjudicate cases under the Guarantee Clause.
Assuming you're right that the Constitution and the courts don't play this great role in protecting civil liberties, but that we as a people give rise to the political equalities that we should be proud of, couldn't it still be the case that the Constitution as a myth and as is deified by the people in general plays an important role in that process?
It's possible. It's a good point. I mean, it's hard to know. Some people argue that in a country that has great racial and religious and ethnic diversity, you need something that kind of binds people together, and that's the myth of the Constitution. That in some meaningful sense, even though my parents or grandparents didn't come from the United States, I still have a connection to James Madison, who I still think of as my founder. I doubt that is as large, that it plays as large a function. Even if you didn't have a written constitution, you would still have what the British think of as an unwritten constitution, which are norms and traditions, symbols that are important, and they would be roughly the same sort of thing. One reason why the Constitution is so attractive to us is that it's so open-ended that people on both sides of almost any debate can invoke the Constitution on their side. So at the time of the Civil War, Southerners said they had a right to secede under the Constitution, while Northerners said, well, of course, it's an indestructible union of indestructible states. Southerners argued that their rights to bring slaves into foreign territories were protected under the Constitution, and Northern Republicans said, no, the Constitution not only doesn't allow you to do that, it actually bars you. It requires Congress to forbid slavery in Western territories. And today, on the abortion debate, one side says women have a constitutional right to abortion, and the other side says a fetus has a constitutional right to life that ought to be protected under the Due Process Clause. So the Constitution is capacious enough that people can largely find in it what they want. The problem is that's not always true. It's true a lot of the time, but there are some provisions that are really clear and people seem disinclined to argue their way around it. So that's why we have 2 senators for every state. That Delaware didn't have a good argument for that in 1787, and Wyoming doesn't have a good argument for it today, and the disparity is vastly greater. Right? Delaware had about 11th or a 12th of the population of Virginia. California has 70 times the population of Wyoming, and Wyoming gets the same 2 senators. What that mostly translates into is A, more federal largesse getting channeled back into Wyoming than it's entitled to, and in today's political world, it enhances the power of the Republican Party because people in those sparsely populated states tend to have values that they think are better reflected in the Republican Party. It is almost almost impossible to defend 2 senators per state in a system that purports to be about everyone's vote being equal. That's one good example. Another good example is actually lifetime tenure for federal judges. As you may know, the states revolutionized judicial tenure under Jacksonian democracy. Beginning in the 1840s, every new state added to the Union had elected judges, and many of the old states moved to elected judges. We would have done that at the federal level, except it's almost impossible to get a federal constitutional amendment on an issue like this. There's no particularly good argument. Most of the rest of the world doesn't do it these things. There's no particularly good argument why judges who are deciding vastly important questions ought to have lifetime tenure, and they're relatively unaccountable. They now serve until their 80s or even into their 90s. That's not a very sensible way to run a system, but it's in the Constitution. It's hard to change. The Electoral College system is another good example of that. 4 times in American history, someone was elected president who did not win the popular vote. That is very difficult to defend. Again, it artificially enhances the cloud of people who come from sparsely populated states. We will never change that because it is so difficult to get a federal constitutional amendment. And that indeed is one last part of the system that is almost impossible to circumvent and doesn't make a lot of sense, which is how difficult it is to get a constitutional amendment. We regularly have 70 or 80% of the country favoring a reform, and yet you can't get it into the Constitution because it is possible for fewer than 10% of the American public to block an amendment simply by acting through the handful of state legislatures. You need 3/4 of the states. All you need is 1 house of a state legislature. So basically something like 7% of the country can block a constitutional amendment. Okay, people have classes, so thank you very much for your attention. Thank you.